like to welcome everybody. Thank you for coming. I'd like to welcome everyone that is here in Sacramento and at the seminar. Thank you so much. And I'd like to welcome everyone who is tuning in on the webinar. Thank you for attending in that way. I wanted to let everyone know that after today, the video kind of pods of each presentation, in about a week, we will have them up on our website, links. So if you have, if there's a segment that you felt was important to some folks in your office that they should view, you think it would be interesting to someone, you'll be able to direct them to the link, and the presentation, just that presentation you'll be able to see. So you won't have to go through all four of them. If there's one in particular that you're interested in, you'll be able to click right on that and watch the presentation. Also, the link I sent you in an email, if you didn't receive it, has the link to all of our materials, including the PowerPoints. You also have had it offered to you on a flash drive and in paper. So multiple ways to have the materials. If for some reason you need additional set of materials, you're welcome to bring, there's extra binders here. You can bring them to colleagues or your whoever you think might be interested in having an extra binder or a flash drive. We've got plenty. And we are going to have 4 presentations today. The first 2 we'll have back to back. Then we're going to take a break for some refreshments. Then we'll have sorry, I just wanted to make sure that wasn't somebody contacting me from the webinar. But we'll have 2 further presentations, and then we'll have cocktail hour, and which is always good. And the last presentation is, I'm told, is going to be very entertaining. It's not going to be about cases. It's going to be sort of done in a skit form. There's even a costume. So make sure you do not leave early. You have to make sure you're here for the whole thing, because the real treat is the last presentation. And so I'd like to introduce to you our first two speakers. We have Eric Fonferek from our Monterey office and Leeh Dibello from our San Francisco office. They both work in civil litigation, all aspects, employment, construction, personal injury. Eric works closely with me on many of my cases, and they both have very interesting careers before they came to Loball and Lynch. Eric was in the military. He served for 8 years and with a stint in Germany. He speaks German. And Leeh, and that's just a tiny bit about Eric's background. He's also been in private practice, and Leeh worked for the Public Defender's Office and has worked in many different capacities in different law firms, and so she has a lot of varied experience that they bring to the table, as well as everything that they've been able to work on at Loball and Lynch. So they're very experienced and have a great deal of insight on these cases. The update from 2015, 2016 California case law update. So welcome to Eric and Leeh.
Good afternoon, everybody. Can everybody hear me? All right. I'm Eric Fonferek, as Christine said, from the Monterey office. Leeh Dibello, my colleague here, is from the San Francisco office of Loball and Lynch, and we have the distinct pleasure today of taking you through some interesting, noteworthy, and in some cases entertaining cases here from the last basically 18 months. So what we're going to do, I think how we're going to do is we have about a half hour or so. We want 8 cases to present. Leeh and I are going to go back and forth between cases. When I finish, Leeh will pick up, and then vice versa. And we decided before that it'd probably be a better idea for everybody to ask questions, open up the floor to questions after each case, instead of at the end when we're 8 cases in, and what was that first case about again? So we'll do it that way. Just a few questions though, because we do have a bit of a time limit. So the first case I'll direct you to is in, page 1 of your materials. And it is the Griffin versus Haunted Hotel case, and that's a 2015 case regarding assumption of the risk. So what happened here in this case, basically, is Mr. Griffin. This has happened down in Southern California. And I thought this was very topical because we just had Halloween, and so, just a few days ago. So it's nice to lead off with a Halloween case. Mr. Griffin attended the Haunted Hotel with some of his friends and had a good time from all accounts. And at the end, as his friends and he were exiting the Haunted Hotel after having a good fright, they went through a hole in a fence near the exit, or on the way to the exit, on the way to the parking lot. Well, after this, he and his friends had gone through the fence. A man jumped up with a chainsaw, scaring the living you-know-what out of Mr. Griffin, who in turn took off running, tripped, fell, and broke his wrist. So what wasn't known at the time is that, unbeknownst to Mr. Griffin, is that hole in the fence was intended by the Haunted Hotel as the final fright. People had the option, basically, in their view, to either go on the main route to the parking lot, or there's this big hole in the fence, which is shorter, so most people would go through it and then be scared by the chainsaw man. The chainsaw, one of the relevant facts, had no chain on it, so there was never any mortal danger for Mr. Griffin. And so the chainsaw scare was intended to be the final scare of the patrons. So Mr. Griffin sued for negligence, assault, and punitive damages. There was a defendant filed for summary judgment, which was granted, which was then brought up on appeal in what we're going to be talking about here regarding the relevant facts. Just as a little bit of a backup, what Leeh and I both are going to be doing today is basically we're going to take you through the relevant facts of each case and then the applicable appellate court analysis and ultimate holding, because that's what everybody wants to know here is, what did the court do? What do I need to know about going forward in my career here regarding these cases? So the appellate court had, in this case, relied heavily on the previous case called Nalwa, which had to do with primary assumption of the risk, or PAORs, I'm calling it here. And PAOR is applicable as a defense. It's a viable defense. Oh, I'm sorry, Yep, I'm there, I'm in the right spot. When there's a recreational activity, sporting or otherwise, which involves an inherent risk of injury to its voluntary participants. So, football game, skiing, haunted houses, they all have some sort of, you could theoretically be injured by just taking on these activities. And so the defense will bar recovery, basically under the Nalwa case, if two things are present. One, that the risk cannot be eliminated without altering the fundamental nature of the activity. So that goes to kind of most of assumption of the risk cases, where if you're going skiing, there's always a chance you're going to fall, and there's nothing that the hill can do to make you falling any less likely. You're going to play a football game, and the nature of the game is such that you could be, and probably will, being a former football player myself, you will be injured. It's the sort of the byproduct of the sport. So basically what the Griffin court ultimately held in this case is that the perimeter fence, that was a big bone of contention, whether the perimeter fence that Griffin went through was actually part of the attraction or was not. The court held that it indeed was part of the attraction, even though it was on the perimeter. It was part of the attraction, therefore bringing it squarely within sort of the zone of danger, for want of a better phrase, of being frightened, to which he was. And the attraction, it did not unreasonably increase the risk of actual harm. He could have been harmed just as easily being startled inside the haunted house or on the periphery, on the grounds outside the house. That's what the court held. And it did not unreasonably increase the level of harm to the intrinsic nature of the activity, being the haunted house. The primary assumption of risk was therefore a viable affirmative defense under the facts, and the summary judgment was upheld. So, as we said before, we're going to take a few questions after every case, so I'll open the floor real quick. All right. On to the next one. Comments? Yes.
Okay, I guess I'm up next. The case I'm going to be discussing, I think, will create some sort of argument or disagreement in the way the case came down. This is a premises liability where a nightclub was held liable for the rape of one of its patrons. What happened here was there's a 37-year-old plaintiff in West Hollywood who went out for drinks with her friend. She decided to go to the Here Lounge in hopes that she would meet her friend when she arrived there. Now, the Here Lounge is a big club. Oh, I'm sorry, it's on page 15. Okay. Everyone got it? Okay. All right, so a 37-year-old plaintiff goes out for drinks with her friend early in the night in West Hollywood. She decides at some point in the night that she's going to go to this club. It's called the Here Lounge. And it is a pretty big club, and on Sunday nights, the night in question, it has up to about 500 patrons. So the plaintiff goes to the club and she cannot find her friend. She realizes that she's been drinking some that night, so instead of ordering a drink, she gets some water. The bathrooms at this club are designed to be unisexual bathrooms. I think all of us have probably been in bars or restaurants where we see these new type of bathrooms that are made for men and women. I think it's to try and help people get through the lines quicker, there's no backup. But the way the bathroom was designed was that there are 4 unisex stalls, and then there are 2 ADA stalls which have full doors and locks. So someone standing on the outside cannot see what's going on in these ADA stalls. Now, these ADA stalls, one's marked for a woman and one's marked for a female or male. However, patrons use both of them. So what's happened in this club is that there has been instances of consensual sex going on in these unisex bathrooms, as well as drug use going on in the stalls of these unisex bathrooms. So what the club did was that they posted 2 security guards to stand near the bathrooms and to monitor them to make sure that no more than one person was entering in these bathrooms at one time. Now, of course, they had security guards throughout the rest of the club because that's required by the local ordinances. But they specifically put 2 guards here for this purpose, to keep people from doing drugs and having sex in these bathrooms. However, these security guards that were posted at the bathrooms were also given the ability, if they so chose, to leave the bathrooms when they weren't crowded or the club was dying down and kind of go out and roam the rest of the club and check to see the security around the rest of the club. So they could leave their posts if they felt that there wasn't much going on in the bathrooms. Well, on this night, it was 1:30 in the morning. Plaintiff decided she's going to use the bathroom. When she went to the bathrooms, there were no security guards posted at the locations where they normally were posted. She went into the ADA bathroom, did not lock the door. As she was turning around to sit down, a busboy from the bar entered the bathroom and raped her. After the rape, the plaintiff went out onto the street and got the assistance of a bystander who called the police. She was taken into the hospital and a rape evaluation kit was performed, and they took some DNA samples from her clothes. About 9 months later, the busboy, his name is Victor Cruz, was arrested for theft at the club. When they took him in and they took his DNA evidence during the arrest, they matched his DNA to the plaintiff. The plaintiff then sued the club and Victor Cruz for negligence, among other things. The jury returned a verdict in favor of plaintiff on premises liability cause of action and awarded her $5.4 million worth of damages. 60% to go to 60% responsibility for Victor Cruz and 40% to the bar. Bar appealed. And the issue that the court had to consider was whether the club owed a duty to use reasonable care in securing the restrooms for its patrons. And what the court did in analyzing this was that they did a balancing act. Number one, they looked at the foreseeability that a rape would occur balanced against the extent of the burden the club would have in preventing the harm. The court determined that the club was on notice based on the facts that were foreseeable that a rape would occur. And these are the facts that they pointed out. They stated that the club promoted a sexually charged atmosphere, that they allowed their bartenders to wear shorts or underwear, and that promoted sexually charged atmosphere. Also, they said that the theme of the night when the plaintiff visited the bar was size matters. Now, I don't know, I live in San Francisco. I've been to a lot of bars. I've seen the bartenders wearing underwear and shorts, and that's a lot of clothing compared to some of the things we see there. Also, the court said that the club designed an open restroom area allowing for unrestricted area for men and women. Now, I know in my experience, just going to clubs that do have individual bathrooms for men and women, I always see both sexes going into each of them. So I'm not sure the fact that there's a unisex bathroom would have created a dangerous atmosphere, but the court really honed in on that. Also, the court stated that the club knew that sexual activities in the restrooms and elsewhere in the club was an ongoing issue. The club also knew that it was common that patrons would forget to lock the bathroom door. It's interesting because I don't know what sort of evidence was used to establish that it was common that the patrons did not lock their door. The evidence also showed that the owner and the club manager and head of security also recognized that the danger that sexual conduct behind the closed doors could have turned into a non-consensual situation. The court held that this evidence made the risk of harm to an intoxicated and vulnerable patron reasonably foreseeable, regardless of whether the club was on notice of any similar incidents. And then what they did was they balanced this with the burden on the defendant. They noted that the club had already assumed a duty of posting 2 security guards at this location, and that having those security guards there at all times and not allowing them to leave that post was very minimal. It would have been no burden at all to have the guards stay there during the whole time. The added burden was minimal. It required only that guards always be present in the restroom area when the club was open, and removing their individual discretion to leave the restroom area when the patron is dwindled. So the court affirmed the judgment on this. What's interesting about this case was that it was an evidentiary case. There was a lot of things that were allowed at trial that probably shouldn't have been allowed. For example, the perpetrator, Mr. Cruz, wasn't present at the trial. However, the court allowed his statement that he made to the police officers during his interrogation to come in as evidence. Of course, the defense argued it's hearsay, and plaintiff said, well, it goes to his state of mind, and it was allowed in. What's even more interesting of what was allowed in was evidence of the busboy's brother, Victor Cruz's brother, who worked in another bar owned by the same bar owners as this club, evidence that he had had consensual sex in a bathroom with his girlfriend in another bar. That evidence was allowed into this case. Now, that's a leap. Just on a note, the perpetrator, Victor Cruz, or the alleged perpetrator, was actually charged in the criminal case. The first trial resulted in a hung jury, and the second trial he was acquitted. So, anyway, does anyone have any comments on this case? Any thoughts about, do you think it's a scary case? I mean, this kind of changes the whole fabric of being liable for the criminal acts of someone else. I mean,
More circumstances whatsoever. So you basically said it was just foreseeable. Yep. And because of that, that's how they hit on negligence. So nothing at all that happened of a similar nature.
nothing, nothing.
I find it interesting that they didn't put any negligence on her for not locking the door. You're in a public place. You go into a restroom, you know anybody can walk into it at any time. You don't lock the door and they don't put any negligence on her.
There was no comparative fault, none.
Do you think it would have made a difference if the bar had never posted guards there?
Yes, absolutely. I think there are a couple of turning points in this case, and one I didn't mention. Plaintiff was a virgin, and she lost her virginity as a result of this incident. So I think that got the jury very heated. Also, I think the problem was at 37.
Okay.
I said the same thing. I had to check her age. But I think too, what really pushed the court in this case was the fact that they took on this duty to put these two guards at the bathroom specifically. They almost set themselves up here. I mean, yes, it was required by local ordinance to have security guards in these bars and clubs. There was no requirement for them to put these guards at the bathroom. And I think that the fact that they did that set a higher standard here, a higher duty for them. And the fact that they weren't there the whole time and they could have easily been, I think that was a turning point in the case.
And it also adds foreseeability reasoning in court. I mean, if you're doing that, you should foresee some problems like that.
Foresee that someone would be raped in a bathroom?
Yes.
In a bar?
Yes.
I think I mean, I know everyone has a different opinion. I think that it's a far stretch to go from people doing drugs and having consensual sex in a bar to, oh, if these people are doing it, someone's going to be, as the nurse that examined the plaintiff is going to be violently raped in a bathroom.
But they were looking at the sexually charged minors, the things you talked about. So undoubtedly,
That's right.
somehow they made the connection with the content of what was going on in the club, increasing the risk of any incidents, and therefore foreseeability followed. And if you were having guards, you saw it too, even though you had that previous incident. So I'm not
Okay.
saying they're right, but it's
We're gonna get on to the next one real quick though. Thanks for the questions.
Just point something out, Leeh? Would
Yeah.
that be okay?
Yeah.
Point something out. Another thing, of course, that did not come into the trial is that, and he was acquitted, the first criminal trial, there was a hung jury, and he was acquitted in the second trial, in the criminal trial. So, and of course, that did not come in because the burden of proof is different in a criminal trial, okay? But clearly, that gives you some inference. But they allowed in.
How can they acquit him on a DNA match?
And they knew the guy would come in.
We knew this case would spark some
Yeah,
debate.
Just to note, I think somebody asked, what about the DNA evidence? There was argument from the defense that it was a consensual interaction between the two of them. So he wasn't denying that he wasn't in the bathroom with her. Their defense was that it was a consensual.
Let me just say that we have 8 cases and we have to move on, but we're gonna have a break, and you can talk to them more about it at the break and or after, and more than happy to give them a call after. You can talk to them about it. Also, if you guys, when you get a comment, if you could please restate what the comment is, so that those attending the webinar don't hear a big silence.
Right,
So
that's a
if
great
you
point.
could,
That's a great point.
Oh, okay.
Okay,
hear
forgot we're
anything but you
on
guys.
candid camera. Okay, so the next case, I chose this because our lives on a day-to-day basis are so much online, and that is affecting both the state of the law and the state of insurance coverage more and more each day. So I thought this was topical, and that's why I decided to put this one in here. This is regarding social media postings, Facebook in this case, from one state into another state, and then the court's trying to figure out which state has the proper jurisdiction. So the facts in this case are the defendant, Burdick, was a consultant for a national skincare products company. He was an Illinois resident with no real significant or viable ties to California. The plaintiffs, the California plaintiffs, some of whom were medical professionals, scientists, they publicly criticized on, I'm sorry, this is at the end. This is 38, my mistake. I'll make sure not to do that again. They publicly got on the company's website, of which Mr. Burdick ran the website, and started publicly questioning the scientific research and effectiveness of the skincare product. Mr. Burdick then, in turn, responded to their complaints by basically, putting them on blast, I guess. They're going to misuse their social security information. They're going to, he put up public information that one of the doctors that questioned him lost his medical license, that another one of the critics had been convicted of domestic violence, all sorts of things to attack, basically, I guess, the veracity of these people's claims who are putting things on Facebook about this company. So the plaintiffs, or the California residents and Facebook users became the plaintiffs, responded by filing suit against Burdick for defamation, and they sought jurisdiction in California. That basically is what we're talking about here. Is he's in Illinois with very few or any ties to California. The plaintiffs are in California. Where's the jurisdiction proper? And what the court basically ended up saying is that the plaintiffs argued that he had intentionally targeted them. Okay, they were California residents, and he targeted them as individuals on Facebook. And therefore, the California venue and jurisdiction would be proper because he targeted them in the state in which they lived. They also contended that Burdick knew, or should have known, that his comments and airing of their, shall we say, dirty laundry would have a negative effect on them in the form state of what they're arguing, California. But the appellate court really didn't buy those arguments and ultimately held that the California jurisdiction was not proper for a couple reasons. The postings themselves targeted the individuals only and did not really have anything to do with California as the forum state itself. Didn't have anything to do with the government, didn't have anything to do with any sort of the infrastructure, for want of a better word, of the contact with the actual state. It was just these people as individuals. Also, that one of the facts that the court relied upon was, in making its analysis, that people from all 50 states got on this Facebook page and talked about the product, not just California. So there was nothing really unique about California with regard to the company's Facebook page in and of itself. And there was not a significant audience in California. It's for this site, for this Facebook page. And very few of Burdick's Facebook contacts, the people he was basically broadcasting to, and thus may associate the plaintiffs with the information, were actually from California either. Most of his contacts were from other states. So in the end, the court deemed that jurisdiction in this case of California from a Facebook posting from Illinois, California was not the proper jurisdiction. So any comments real quick on that? Okay. We're going to go to Ellenwood case. Santos. Okay. Next.
Okay, next one I'm going to do is related to elder abuse. If you could get to, it's like page 6. I'm just going to skip that one for now because we're going. Okay. So this case concerns mandated reporters and immunity from civil and criminal liability for reporting the abuse of elder abuse. Under the Elder Abuse and Dependent Adult Civil Protection Act, mandated reporters are statutorily required to report suspected instances of abuses such as financial abuse. To ensure that the mandatory reporters report, they also have absolute privilege against civil or criminal liability in reporting making reports. So the facts of this case are that shortly after plaintiff Santos was hired to work in a senior living facility, the number of thefts rose. The Escondido Police Department, this is down in Southern California, got involved and started to conduct an investigation. Following the investigation, the police advised the community, the senior living community, to place surveillance cameras in some of the residents' homes and also put bait money in some of the lock boxes in one of the residents' homes. The following morning, the residential relations director, her name was Ms. Gutierrez, discovered that $40 was missing from one of the lock boxes. After she reviewed the surveillance cameras from the room where the lockbox was located with her executive director, Mr. Rick Lansford, they called the police to report the suspected crime and identified the plaintiff as a suspect. So the video showed the plaintiff near the lockbox. The video showed plaintiff touching the lockbox. There was never any video showing her actually removing the money. This was like a motion censored sort of video, and it didn't always capture all of the movements. However, the video did not show any other individuals entering the room or going near that lockbox other than Ms. Santos. The police conducted the investigation and they searched Santos. The serial numbers on the money that they found on Ms. Santos did not match the bait money. At that time, the police asked Mr. Lansford if he desired to prosecute, and he said yes. The police officer then handed Mr. Lansford a form which he signed. Ms. Santos was issued a citation and told to appear at the Vista courthouses. The charges against her were later dropped. Later, Ms. Santos then filed against Ms. Gutierrez, Mr. Lansford, and the two entities she believed were responsible for their conduct. She alleged causes of action for false arrest, malicious prosecution, assault, battery, negligence, defamation. The trial commenced, and the trial court denied defendants' request for jury instruction, providing that mandated reporter immunity only protected the report, but conduct as well. So they were arguing that the immunity for a reporter not only protected making the report, but also their conduct of signing. The court refused to allow that instruction. The trial court dismissed Gutierrez from the case based on its determination that the plaintiff's claims against her were barred as a matter of law by the doctrine of mandated reporter immunity. Now, if you recall, Gutierrez only reported it. She had nothing to do with the actual signing of that affidavit for a citizen's arrest. The court also dismissed the remaining causes of actions with the exception of the false arrest and intentional infliction of emotional distress against Lansford and the entity defendants. The trial court determined that Lansford signing the citizen's arrest form constituted conduct, and it fell out of the protection afforded by the mandated reporter immunity. The jury found in favor of plaintiff for approximately $66,000, and the defendants appealed. On appeal, the court determined that there was no question that the mandated reporter immunity immunized defendants from the liability to call the police. However, it found that it was a more difficult question as to whether Lansford's act of signing the form that effectuated a citizen's arrest was similarly protected. What the court did was they looked at a string of child abuse cases. The immunity and mandating reporting requirements in child abuse cases are pretty much identical to those of the elder abuse cases. And what those cases said, that acts such as like a doctor that may examine a child to determine whether abuse is happening consisted of conduct, and therefore they report it. That doctor would be immune from civil and criminal liability. So this court had no problem at all applying that line of thinking to the elder abuse cases. The Court of Appeal concluded that Lansford was immune from plaintiff's claim because his act of signing the arrest affidavit was closely related to the report of suspected financial elder abuse and fell within the sweeping immunity conferred by the immunity section 15634. What's interesting about this case is the court specifically narrowed the conduct at issue as the signing of the form that effectuated the citizen's arrest, and specifically recognized that Lansford did not participate in the search, interrogation, or prosecution of Santos. The question remains, I think, as to whether immunity would have applied if that conduct would have been charged against Mr. Lansford. Any comments? Questions?
All right, next topic, which is, I think, always of interest to insurance professionals and lawyers alike, are 998 offers. And it's kind of an always evolving area of law. And the one I'm going to comment today is brand new. It's 2016. It's Toast versus Cal Portland Construction out of the 2nd District. The facts are are not necessarily all that important in this case. It's what happened after, but I'll just give you a quick taste of what happened. The plaintiff was killed when a co-defendant backed up in a construction site with a big heavy truck, hit him during a road paving project. The plaintiff had been standing behind the truck in a blind spot. Mickelson, the co-defendant, agreed to take a drug test, which came back positive for marijuana, which he had smoked 2 days prior. Basically, the court didn't give a whole lot of stock to the marijuana issue, seeing it happened a few days ago as a cause of the accident. What's really relevant here is the defendant, Cal Portland. There are many defendants in this case, but the one I want to focus in on is Cal Portland because of what they did. They incorporated basically a settlement agreement with a release into its statutory 998 offer, which was then subsequently rejected by the plaintiff. And this one was for $15,000. I didn't put that in materials, but it was for $15,000. The jury returned the defense verdict specifically for Cal Portland. Toast appealed, contending that defendants were erroneously awarded the expert fees as a cost based on the 998 pretrial offers and compromises, specifically because there was a settlement and release associated with the 998 offer. That was really their bone of contention. So basically, what happened then was the court held that the release was okay, and really the agreement was okay so long as long as it was non-conditional in nature. To just give somebody a release and for payment of money was not considered conditional. It was only for the dismissal in return for the exchange of dismissal for money. It contained no other contingencies, and it did not require release from causes of actions that were outside the scope of the litigation. So it wasn't like a blanket release for everything to come or retroactive. The court also said that Cal Portland's settlement agreement was proper and did not bar it did not preclude their recovery under 998 because they did not beat their offer. Other co-defendants in the case did, however, offer conditional settlement agreements which were rejected by the court, such as some did good faith settlements, etc. Their 998 offers were invalidated. Another very important part of this case is that, frankly, I didn't know until I really delved into this a bit further, is that in 2005, the California legislature made an amendment to CCP 998, which basically stated that if a plaintiff rejects a defendant's statutory offer and then subsequently is not able to beat that offer at trial, they're on the hook for both pre- and post-offer expert fees. The same did not apply to the plaintiff in the same position. Brand new this year, January 1st, 2016, the court closed that loophole and said both parties, upon rejection of 998 offers, will only get post-offer fees. That to me was striking. That went on basically for 11 years before that was changed, because what was happening were that basically why the legislature did that is that defendants were waiting a very long time and accruing a lot of fees before they hit the plaintiff with the 998 offer, knowing that they would be able to get this. So this closed the loophole, and this case, the Toast case, was one of the first ones to come out regarding this closing of the loophole, which said that part where post-offer recovery is possible to both plaintiff and defendant, applies to all cases currently on appeal. So that was the secondary holding, which is also very important in this case. Any questions on this one? Okay. No? All right.
Okay, the next case we're going to talk about, it's a real property case. It's on page 28 of the materials. It's the last one, yeah. Richardson versus Franck. Okay, the facts of this case. In order to access their home, the respondents had to travel across land belonging to their neighbors on a 50-foot long road, which was authorized by an easement for access and public utility purpose. Over a 20-year period, the respondents and their predecessors in interest maintained this roadway. They planted trees, they created irrigation systems, they put in lighting systems, they maintained the landscape, they maintained the irrigation systems, they paid their own landscaper, paid the water bills with respect to the landscapers. They expanded a substantial amount of money in the upkeep and care of this 150-foot road. When appellates purchased the property, they knew that the respondents were improving the landscaping and the easement area and made no indication that they wanted the respondents to stop doing the work that they were doing and to stop maintaining the plants and the landscape. 6 years later, without notice, the appellates cut the irrigation and electric lines and demanded that the respondents remove the landscaping, irrigation, and lighting on the ground. and that the respondent's rights were expressly limited to access, and that the landscaping and other improvements exceeded the purpose of the easement that was granted. The respondents filed a lawsuit seeking to establish their right to an irrevocable license, which would grant them an uninterrupted right to continue to maintain the landscaping and other improvements. After a bench trial, the trial court ruled that it would be inequitable to deny respondents an irrevocable license given their substantial investment of time, money, and labor in the landscaping and other improvements, coupled with the years of the appellate's acquiescence to the work that was being performed on this part of land. An appeal was filed. What the court did is it reviewed the general principles of a grant of an irrevocable license. Number one, a license gives authority to a licensee to perform an act or acts on the property of another pursuant to express or implied permission of the owner. Generally, a licensor can revoke a license at any time without excuse or consideration to the licensee. However, a license may become irrevocable when a landowner knowingly permits another to repeatedly perform on her land, and the license is in reasonable reliance on the continuation of the license, has expanded time and substantial amount of money on improvements with the licensor's knowledge. Under such circumstances, it's considered inequitable to terminate a license. The court in this case found that there was sufficient evidence that respondent and their predecessors and interests had expanded a great amount of money in all of the plants and the trees that they had planted, a great amount of time in maintaining the landscaping, and that there was never any objection for 20 years made by the appellant or the predecessors in interest. Therefore, the respondents had significantly met the requirement for an irrevocable license. The court refused also to limit the duration of the license for a period of time. The appellants were asking that the court put a time frame on the amount of time that they could use this license, and the court refused to do so, concluding that it would be inequitable to require respondents to remove the improvements when the property was transferred, given the substantial investment and time expended in the improvements. The court rejected the appellant's argument at that the trial court had taken the property that belonged to them and ceded it to respondents forever. The court clarified that the license does not create or convey an interest in the property. It merely makes a lawful act that would otherwise constitute a trespass. Any questions?
Yeah, what was the root cause of the beef?
You know, it's never discussed in the case of what actually got these individuals angry. They just one day went out and cut the irrigation lines, cut the electric lines, cut the lines to their house. There's nothing in the materials or in the case that talks about why they turned so quickly.
How about if the license of use was given prior to purchasing the property?
I'm sorry?
The person that owns the property now
Right.
decides, I'm going to, I got the property without any kind of recorded document saying there's something running across my property, or license that I'm using. So we have an unrecorded use, and now it's going to be used as a license. In this situation, were they the original owners and knew that this was happening before they were there?
The appellants, they were not the original owners. They bought the property, and they'd only had it for about 6 years. And they were aware that there was this easement. They were aware this was going on, and they were also aware that these respondents, people that were living there, had been planting these trees and irrigation systems. And they never said anything.
So they took subject to an implied license, is the way the court put it.
So I guess the kind of like the takeaway from this, I would say, is you need to know what's going on to your property. If you don't like something that's happening, you need to address it right away. Because if you don't do anything, it's almost as though you waive your right to do anything to your property. If you allow someone to continue to perform and do things on your property without making a fuss of it or not bringing it up or maybe putting something else in writing, then you could run the chance that they're going to be able to use that property for as long as they want, based on the amount of work and time and money that they put into it.
Did they discuss at all what might constitute a future abandonment of the license if these people stop trimming the trees or fail to maintain the irrigation?
Nope, that was not
That's for
discussed.
future court to figure out.
That was not discussed.
We're going to move on to the next one. This is my last one. This is regarding anti-SLAPP, and I think it's probably a good place to start review. What is anti-SLAPP? Good place to start. This is Abamura versus Stevens, Court of Appeal, Second Appellate District. This was decided last year. SLAPP law, SLAPP is strategic lawsuit against public participation. It's more or less on First Amendment grounds. When a lawsuit is brought and the intent of the lawsuit is to chill the speech of another. Anti-SLAPP legislation was enacted in 1993 to address this, so that these lawsuits, generally on defamation grounds, the party could use this as a defense for causes of action brought merely to just chill free speech and keep the other side quiet. So that, in a nutshell, is what anti-SLAPP statutes are intended to protect against. What happened in this case is there was a roadside altercation between Mr. Stevens, who was an attorney, John Stevens, and Mr. Abelmira, and they both were neighbors in a gated community. Mr. Stevens' friend, recorded some of the the altercation, the verbal altercation, which became slightly physical, with his cell phone. This included expletives, racial epithets, anti-gay epithets. Eventually, a third party came in and stopped it, and the police were called, and the parties were basically sent their separate ways. Mr. Stevens then went on to publish the cell phone recording to both the Homeowners Association, where they both lived, and to a local TV station. During the publications, Mr. Stevens stated that, and it bears noting that Mr. Stevens and his partner are a same-sex couple, and that the anti-gay epithets that were hurled at he and his partner by Mr. Abamera, according to Mr. Stevens, constituted a hate crime against homosexuals. That was included with the publication and reported as such. Mr. Abelmera stated that he didn't know Mr. Stevens before the incident, and nor did he know his sexual orientation. Evidence came forward during the trial that this video may have been doctored, taken by Mr. Stevens, may have been doctored, may have been edited because the GPS for where it was potentially overwritten, was at a different location than where the altercation took place. So there was evidence that there may have been some editing by Mr. Stevens, which put Mr. Abelmera in a false light, and he therefore sued for under false light and defamation. That his video and his actions in that video were taken out of context. So Mr. Stevens then defended against that, stating that you're intending, like we talked about earlier, you're intending to chill my free speech. I'm speaking about a matter of public interest, and I'm going to employ the anti-SLAPP statute against you, so as a defense to your defamation suit. The appellate court then, and this is the rule that you take out of this case, is the appellate court found that the anti-SLAPP statute was not unpersuasive and not applicable to Mr. Stevens, and did not involve really an act in furtherance of his First Amendment constitutional rights. And this was not, and it was not, I'm sorry, it did not have a connection to a real legitimate public issue. What really came down here is, in what the court said, is that what Mr. Stevens did was take a private altercation and make it public. And that in and of itself does not trigger anti-SLAPP. It has to be what the court held a legitimate issue of public interest. And we're not persuaded that just because there may have been some unsavory epithets thrown either way by both parties, that the publication of that private altercation does not constitute any type of free speech right that needed to be protected by the anti-SLAPP statute. And that his video and his publication thereof was not a legitimate issue of public interest. So that is how the appellate court came down on that case, in that it limited the anti-SLAPP protection and disallowed the publication of a private event. Any questions on that one? Anybody else? Okay.
I know I've heard you, but go ahead.
One last thing. I have, just fresh off the press, my brand new, I just want to give a little plug for our weekly law resume. I just wrote one last night, and it will be published tomorrow, probably. It has to do with a admission of causation and bad judgment by a plaintiff at trial does not necessarily mean that person was negligent or breached a duty. But what I really wanted to say is that if you're not a subscriber, and this is for everybody here and online, if you're not a subscriber to our weekly law resume, myself, Leeh, all the attorneys here work very hard on it every week to get this out to the insurance community, to keep everybody apprised of important developments in the law. And if you're not a subscriber to that, please give any of the attorneys here after or during a break or tonight during the mixer one of your cards so that we can get you signed up. I just wanted to say that.
I'd like to thank Eric and, can I get to the microphone? Thank Eric and Leeh for a great presentation, and thank you guys very much. They also went to a great deal of effort to put together written materials in your binders that cover many more cases besides the 8 that they covered today. They're organized into topics, so you can go ahead and look at any issue that might be important to you. Those are in the binder and also on the flash drives.